What exactly is an appeal? What does it mean to treat a witness as hostile, and how often does that actually happen?
And are lawyers reluctant to give legal advice? I'd say,
Let's ride. Welcome to the Biker Rebellion. I'm your host, John Jansen, here with Pete Leehey, the founder of the Biker Lawyers, and let's walk through your legal questions. Alrighty, Pete, so let's talk about the justice system. What is the definition of legal advice, and why are lawyers so hesitant to dip into it?
well, legal advice, it's really pretty simple. It's a lawyer giving advice to a person. So the person has a problem, a question about some situation that's happened. So now you've got a lawyer that's not just some dude at the bar giving advice, but giving advice from a legal perspective based on the lawyer's knowledge. So, and are lawyers reluctant to give legal advice? I'd say, if you come into their office, if you come into my office and you are asking for legal advice, I'm not reluctant at all. But if we're hanging out in a bar and some dude just comes up and wants legal advice, that's where maybe lawyers are a little reluctant. And, that's the situation of, hey man, call me at my office Monday.
Right, and it's separation work-life balance, where if you're out and you're having fun, you don't want to be thinking about your job and what you have to do. You want to be able to relax as a lawyer. I get that.
Well, not only that, but if I'm out having a couple of adult beverages, or maybe more than a couple of adult beverages, that's not the time for me to start giving somebody legal advice. Sure. Because the advice I give at that point might be a little different than what I would say Monday morning in my office.
Sure. All right, moving on to the next question. What does it mean to treat a witness as hostile, and how often does that actually happen?
So it sounds like really bad or aggressive, treating a witness as a hostile witness, but really what it means is it's a witness that is on the other side. Sure. It might, for example, in the cases that we handle, we're always representing the person that gets hurt in the crash. We're suing somebody. Mm-hmm. So when we're asking questions of the other driver, that other driver, by legal definition, is a hostile witness. It just means they're on the other side. It doesn't mean they're actually hostile. And the significance of it is, when I'm questioning a hostile witness, I can ask my questions differently. Everybody's probably seen TV shows where a lawyer will say, "Objection, leading question."
Right.
So the significance of a hostile witness is, with a hostile witness, I get to ask leading questions.
Sure.
Because that guy is hostile to the interests of my clients, and for that reason, I can ask the leading question as opposed to just giving him a blank check to say whatever the hell he wants to.
Fair. Now, we had a Facebook community member, and they asked, what exactly does precedent mean, and why is it important?
Precedent in the legal arena means that there is a court case decided somewhere that controls what's happening in the case right now. So typically you're talking about a decision by an appellate court on a point of law where now you're in trial and the trial judge is bound by that precedent in deciding the case or telling the jury how to decide the case.
Gotcha. And you set precedent with every case that gets decided to a degree, yeah?
I'm going to say yes on the appeal level.
There we go. Okay.
So yeah, if it's an appellate decision, especially if it's the Supreme Court, then you've got some binding precedent.
So let's talk a little bit more about that appellate process. How does that work, and what exactly is an appeal?
An appeal comes after a trial. Once you've got your result from the trial, if one party is dissatisfied with what happened at trial for one reason or another, they do have the right to go to an appellate court and have the appellate court look at what happened and decide if it was appropriate.
And when we talk about like an unhappy scenario, like they didn't get the result they wanted, there needs to be a legal basis for this. Otherwise, it's not going to matter to the appellate court.
Well, you know what, and I've said this many, many times over the years when clients talk to me about appeals, and I tell them, I do not file boo-hoo appeals. Yeah. A boo-hoo appeal is from either direction. From my client's direction, it's that's not enough money. And from the defense direction, it's that's too much money. Sure. Those are boo-hoo appeals. And unless it is really wildly extreme, those appeals are going to fail. And what I tell people is you need a legal point, a legal error that happened at trial to really have a legitimate chance of having success on appeal. For example, if the judge allowed some evidence that shouldn't have been allowed into the case and it had a bad impact on the case, or maybe the judge gives a jury instruction that is not a correct statement of law, things like that, those are legitimate appeals.
Who hears an appeal? I know this sounds like a stupid question, but we get it all the time.
Yeah, it's not a stupid question at all. In Iowa, almost every appeal that you file is going to be heard by the Court of Appeals. The Supreme Court very rarely takes up an appeal right away from a trial decision. So you're going to be getting your first decision from the Court of Appeals.
What happens after an appeal, and can it be appealed again if you don't get the result you want from that?
Yeah, and the way you say it, if you don't get the result you want, I mean, if you think that the appellate court also made an error, then you have the right to ask the Supreme Court for what's called a discretionary appeal.
Okay.
Well, you have the right to ask them. That doesn't mean you're going to get the appeal.
Sure.
The Supreme Court is going to tell you whether or not you are granted that appeal, and generally they're only going to grant the appeal if there are inconsistent precedents out there that they want to kind of wrap it up and make everything consistent, or if there's a constitutional law question, but there just aren't a lot of scenarios where the Supreme Court is going to grant a discretionary appeal. And frankly, almost never in a personal injury case.
Fair. So what's a mistrial and why do those happen?
Mistrial means something happened during the trial that is so out of line, might be irrelevant, it might be something highly prejudicial, but somebody does something that is completely out of line, more often than not something they were told in advance not to do, that the judge, upon motion, will say, okay, that was not supposed to happen, it should have never been heard in the jury's presence, and it is so prejudicial that this trial's over, we're going to reboot and start over. And when you reboot and start over, that doesn't mean now.
Right.
It means, probably in 6 months or a year or something.
Sure. How does a judge decide if they're going to get a mistrial?
The classic case is there's something called a motion in limine, and I know that's just lawyer mumbo jumbo, but it's a motion that you file before the trial. And this is part of our job as lawyers, is to recognize these issues in our cases before we ever get to the courthouse in the first place. And you make a motion to the judge before the trial starts that says, Judge, here are some things that this insurance lawyer might bring up during the trial that are so prejudicial, you need to tell him before the trial to not even bring this up, not even ask a question. Classic case. Every motorcycle case we have, if our client's not wearing a helmet, we file this motion to say, you cannot ask or bring up in any way, shape, or form that our client wasn't wearing a helmet. And we win that motion every single time in Iowa. So now we get into trial, and I've actually had this happen, where a witness gets up and they're testifying, and then they say something about,
and he wasn't wearing a helmet.
Objection, Judge, can we approach the bench? And we make a motion for mistrial, and the judge, who at that point is extremely pissed off, says,
Motion for mistrial granted.
It's a big deal, and that's the classic example. It doesn't have to be a helmet, it can be something else, but something the judge has said before the trial even started, you cannot talk about this, and then it happens that the mistrial is going to be granted almost every time.
Let's talk a little bit about what happens if a mistrial occurs. Let's say it gets scheduled out another year. When it gets scheduled out that following year, all the time in between, just is settlement back on the table?
Settlement can happen at any time, really, and I've been doing this a long time, and I have seen settlements happen at pretty much every different juncture it could. A lot of people think that once a trial starts, settlement is impossible, but I've had cases get settled like after we get done picking the jury.
Okay.
I've had cases settle after all the evidence is submitted, but before the decision comes back. I've had cases settled while an appeal is going on. So really, you can settle a case at any time. It's about the only time, and I suppose even after an appeal decision, you could still have a settlement under certain circumstances, but seriously, up until the appeal is decided, I've seen cases get settled at every different juncture you can imagine.
Fair. If you've got any legal questions, email us at jonathan@thebikerlawyers.com and you just might find the answer next week. Until next time, Rebels, ride with us.